The Tribunal, in its pre-hearing report, identified 13 harmonized issues for determination in this petition. These issues were earlier reproduced in this judgment. Issues number 4, in respect of the decision of the Federal High Court of Oshobo. Number 13, in respect of whether the petitioners have established acts of manipulation of the conduct and result of the governorship election in favor of the first and second respondents by the third respondent. And numbers 5 and 6, in respect of imprecision, vagueness of pleadings, and jurisdiction of this tribunal, were all considered and determined earlier in this judgment when the preliminary objections of the respondents were dealt with. The live issues remaining, therefore, are issues number 1, 2, 3, 7, and 12. For emphasis, those issues are reproduced as follows. 1. Whether or not the first petitioner should be declared validly elected and returned as having polled the highest number of valid votes cast at the governorship election of 11th of April 2015. 2. That is issue 2. Whether or not the election of the first respondent is invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act 2010 as amended. 3. Whether or not the first respondent was duly elected by majority of valid votes cast at the governorship election of 11th April 2015. 7. Whether the election and return of the first respondent as the governor of Oyo State in the governorship election conducted on the 11th of April 2015 is not in substantial compliance with the provisions of the Electoral Act 2010 as amended. And finally, 12, whether or not the petitioners are entitled to the relief sought in the petition, having regard to the laws, the grounds and facts of the petition, and the totality of evidence adduced before the trial. All these live issues are itemized as itemized above, will be dealt with together in this judgment. It is right that the law in respect of election result as declared by the fourth respondent in favor of the first respondent who contested as the candidate of the second respondent is very clear. The position of the law is that the result as declared is presumed to be correct and regular until the contrary is proved. This is clear from section 168 subsection 1 of the Evidence Act 2011, which states as follows. When any judicial or official act is shown to have been done in a manner substantially irregular, it is presumed that formal requisites for its validity were complied with. The above provision in the Evidence Act has received several judicial pronouncements. It will suffice, therefore, to state that the Supreme Court, in the case of Abubakar and Yeradua, reported in 2008, while considering Section 150 Sub 1 of the Evidence Act before the 2011 amendment, which is in peri materia with Section 168(1) of the Evidence Act 2011, stated as follows. While any judicial or official act is done, where any judicial official act is shown to have been done in a manner substantially regular, it is presumed that formal requisites for its validity were complied with. In this case, The acts of announcing the result are official acts within the meaning of Section 150, subsection 1 of the Evidence Act. The burden was therefore on the appellant to prove that the acts were not done in a manner substantially regular. In the same vein, the Supreme Court in the case of Buhari and INEC, also reported in 2008, stated as follows. Election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption. The petitioners are challenging the result of the governorship election conducted on the 11th of April 2015 and return of the first respondent. In so doing, they filed this petition in which they made several allegations as stated and itemized earlier in this judgment. As the onus of proof lies on the petitioners, the evidence given and the documents tendered by them in establishing their allegations must therefore be scrutinized and considered. The summary of the evidence of the witnesses called by the petitioners, including the documents tendered by them, has already been made in the preceding parts of this judgment. It will suffice, therefore, to refer to them in the course of their consideration in relation to the allegations made by the petitioners. The principal witness of the petitioner is PW1 Bimbo Adegoju, a farmer that deals in arable and the cash crops. He was the leader of the team assembled by the petitioners to conduct inspection of election materials pursuant to the order of the tribunal of the 20th day of April 2015. He rendered opinion on electoral materials and documents while he is not an expert. He stated that he joined Accord Party in December 2010 and has participated actively in the campaign of the first petitioner, whom he wanted to win, and said he won. Exhibits 1 to 92 were all tendered for him. Learning senior counsel to the respondents have all submitted that PW1, not being an expert, but a farmer who possessed no skill or experience at all, cannot give opinion or evidence as he purported to have done in the report of inspection as contained in his statement on oath. His evidence, therefore, he contended, must be expunged, having violated the provisions of sections 67, 68, and 128 of the Evidence Act 2011. Reliance was also placed on the cases of ACN and Nyako, reported in 2013, UBN and Ozigi, reported in 1994, and Womi Toju and Kiki, reported in 2009. Learned senior counsel to the first respondent further submitted that PW1 in both his statement on oath and under cross-examination admitted his deep interest in the subject of the petition. He is someone who has his eyes on benefits to be derived from the success of the petition. His witness statement and the analysis done by him were therefore forbidden under Section 83, Sub 3 of the Evidence Act 2011. Reference was also made to the case of NSITFMB against HIFCO Nigeria Limited, reported in 2010. The petitioners in their reply submitted that the law gives leave to the petitioners or respondents to inspect electoral documents for the purpose of instituting, maintaining, or defending an election petition. And under the law, the petitioners or respondents or their agents or members of their party or experts, etc., can carry out the inspection. It is therefore of no moment, he submitted, that the first petitioner's witness, who is a member of ACO, was among those who carried out the inspection. No interest whatsoever can come to play on the face of concrete documents which are not the personal property of the petitioners or respondents, he further submitted. Expert witness becomes necessary where the report goes beyond mere inspection of documents. The law only enjoins the petitioners who are given leave to inspect documents to report back to the Honorable Tribunal. Petitioners' leading counsel submitted that all the cases, therefore, relied upon by the respondents are irrelevant and inapplicable. He referred to the cases of Famurewa and Onibodo, reported in 2010, and Omitiro and Patricia Ete, reported in 2011. Learned Senior Counsel to the first respondent in his reply on points of law submitted that the submission of the Learned Senior Counsel to the petitioners that the evidence of PW1 did not breach the provision of Section 128 of the Evidence Act is misleading. This is because PW1 Dembo Adepoju admitted unequivocally under cross-examination that he was interested in the outcome of the matter and confessed that he wanted the first petitioner to be declared the governor of Oyo State. PW1 has also admitted under cross-examination that some of his analysis, calculations, and conclusions were wrong and contradict the very documents he purportedly inspected. He further submitted that the court is entitled to look at its record. He placed reliance on the cases of Dagash and Bulama, reported in 2004, and Abahu Moro, reported against Duebe, reported in 1999. Furthermore, Learned Senior Counsel submitted that contrary to submissions of the Learned Senior Counsel to the petitioners, that they did not need to call an expert witness because what PW1 did was a mere inspection, court and non-court, of documents. The petitioners have themselves admitted in paragraph 1.06 of same reply that PW1 analyzed and narrated documents in the course of his inspection to inform his report and conclusions. It is therefore an admission against their interests, and the respondents are entitled to rely on same. It is his submission that PW1 at any rate does not have the expertise to analyze INEC documents. Consequently, any result or report of PW1 cannot be relied upon by this tribunal. This is despite the fact that leave was granted to the petitioners to inspect the INEC documents. He referred to the cases of Odukola and Papers Back Limited, reported in 2006, Ipinlai against Olukotu, reported in 1996, and Buhari 9, reported in 2008. In deciding this issue, we have carefully looked at the evidence of PW1, Bimbo Adepoju, their analysis and report of inspection. it is clear that he is not and did not claim to be, he is not an expert and did not claim to be one. He categorically stated that he is a farmer who deals in arable and cash crops. The witness himself at paragraphs 7 and 8 of his witness statement was stated thus, and he is quoted, "In this report, our team, among other things, analyzed the number of PVCs or voters purportedly captured by card readers in such disputed polling unit, number of voters purportedly accredited in the voters register claimed to have been used in each of the disputed polling units, number of purported voters accredited in voters register, number of purported votes cast in the voters register according to the ticking of the appropriate boxes provided in the said voters register, and purported number of voters accredited, valid votes, rejected votes, and total votes cast according to the entries in each of the forms EC8A in respect of each of the disputed polling units." He also said in his evidence in chief, the focus of our inspection was to establish the case made in respect of each of the disputed polling units. Under cross-examination, PW1 has stated that he joined Upward Party in December 2010 and has participated actively in the campaign of the first petitioner and wanted him to win, and said he won. An inexplicable and unexplained errors were fully demonstrated. Suffice it to say that the difference between votes in Atiba local government Ward 1, Unit 1 in Exhibit 5A and the one of PW1 analysis as contained in page 85 is 90, and that of Atiba local government Ward 1, Unit 4 in Exhibit 5D on page 85 with analysis is 12. Further, it was elicited from him that contrary to the allegations that there was no accreditation, it would not be correct to say that there was no accreditation. He also stated that he and his team of inspectors did not use voters' registers or form ECTA in their analysis, which is contrary to what he stated when he clearly said that their analysis was based on available documents, card readers, PVCs collected, register of voters, from ECTA and incident reports. Now it is very clear that inspection of electoral materials, voters' card, voters' register, and the card reader machines are within the ambit of documents that need to be handled by knowledgeable experts, since they are scientific or technical in nature. And from the totality of the evidence of PW1, it is very clear that he led a team of inspectors to gather facts, examine the electoral materials, to ascertain whether there are irregularities, non-compliance with the manual for election officials, and electoral act. They have done that and have brought out facts as contained in their analysis and report. However, although the Supreme Court has held that any literate person can look at a document and bring out facts, they have made their personal observations on the electoral materials as contained there. But their evidence as presented by the evidence of PW1 cannot be accepted as an expert evidence under Section 68, Sub 1 of the Evidence Act 2011. The evidence of PW1 not being an expert cannot be relied upon. See the case of Omisore and another against Arabishola and others, reported in 2015. Furthermore, the Supreme Court has held also in the case of ACN Nyako as follows. Where a court or tribunal requires to form an opinion upon a court specified thereunder, the opinions of persons specially skilled in the areas are admissible. It is a condition precedent to the admissibility of the opinion tendered to enable the court form its own opinion that it is that of the persons specially skilled in the area the court or tribunal is required to form its opinion on a court. The qualification, experience, and depth of the person's learning are invariably the criteria which entitle him to render his opinion in order to aid the court or tribunal. The person so qualified under the section is called an expert. His opinion is necessary and so admissible because same is outside the experience and knowledge of the judge as a judge of fact. It is the court's prerogative to determine that the person being called as a witness by his qualification and learning on the subject in which the court requires his opinion and the reasons for the opinion is indeed specially skilled. In the instant case, the tribunal was right to have rejected PW 66 statement following the correct exercise of its discretionary powers. PW 66 by qualification and learning is not an expert in the act of establishing multiple registration and voting in elections, special skill in respect of which would have entitled him to assist the tribunal to form its opinion on the point. Now, placing reliance on the above authorities, we hereby hold that the PW1 Bimbo Alekoju, a farmer that deals in arable cash crops and the cash crops, is not competent to testify and present a report of the inspection team that he led in respect of the inspection and analysis of INEC documents which they made to establish the allegations made by the petitioners in this petition. He is not an expert, nor was it shown that any of the members of the team is, as the law requires. Consequently, his evidence before this tribunal cannot be relied upon by the tribunal. Furthermore, Section 83, subsection 3 of the Evidence Act 2011 has provided as follows. Nothing in this section shall render admissible as evidence any document made by any person interested at a time when proceedings were pending or anticipated involving a dispute as to any fact which the statement might tend to establish. It is not in doubt that the statement and order to inspect were made at a time when proceeding was pending or anticipated. Statement and the report of PW1 therefore are not admissible. This is based on the fact that he has campaigned for the first petitioner whom he wanted to win, and according to him, won. The errors and discrepancies between his statement on oath and the answers elicited from him under cross-examination support the fact that the sole purpose of the inspection, as PW1 stated in paragraph 8 of his statement on oath, was to establish the case made in respect of each of the disputed polling units, which clearly shows that he and his team were not after establishing the proof. PW1 is therefore an interested person, and the Court of Appeal has held that even if he were an expert, he is not, which he is not, his evidence cannot be relied on. See the case of Awuse and Odili reported in 2005. In the same vein, contradictory evidence elicited from PW1 under cross-examination by the senior counsel to the first, second, third, and fourth respondents renders his evidence unreliable.